to continue the walk there, that's 287, which we started last week with Eric Fitzpatrick. Please have Katie with us this morning to continue that walk and to respond to a number of questions that were raised that we walked through previously.
On the emergency exam application, along with the physician's certification that's part of the EE, and the application for involuntary treatment. So it's, again, a paper review, no testimony. And that is to occur within 3 days of the application for involuntary treatment being filed. And this is happening for everybody. It's not voluntary. This is an extra layer of process for all persons who are going through the proceeding.
How long can it elapse between the EE application that's filed in the emergency room and the AIT filing?
Okay. So after the person has had their emergency exam, if they're deemed a person to need further treatment, then there's 72 hours. And within those 72 hours, the person either has to be committed voluntarily or the application for voluntary treatment has to be filed.
So 72 hours from the EE, that's the statutory, so it can't be longer than 72 hours. Even if the person hasn't been admitted, they're still in the emergency room.
I believe so, yeah. Then the application has to be filed after 72 hours to hold them there, or else they have to be returned to their home or whatever.
Katie, you can't see, but I'm getting a no.
Okay.
So I'm confused. As to what really is going on.
Okay.
I'd ask the commissioner to talk to that. I'm AJ Rubin from Disability Rights Vermont for the record, and my understanding is that people are held for days and days before they're admitted to the hospital when that 72 hours starts. Some people are held in prison for a month before that 72 hours starts. So I would ask the commissioner.
Our question is, when does it start? Does it start in the emergency room? Does it start in jail, whatever? Or does the 72-hour time frame start when there is a bed in a room as opposed to the emergency room?
An admission to the hospital versus being placed in the emergency room.
And so can you say again what the law says? It may not, what the law says might be different than what is practiced.
Okay.
And, well, my question was specific to when the EE is completed, which may be another time frame also, but how long between, is there a restriction in statute in the time frame from when the EE is conducted, because that's part of the application, and to when the application has to be filed? It's a similar question.
I get the question. There are a few questions in there. So, so what the statute says is that 72 hours after a person has had their emergency exam and has been deemed to need further treatment, that an application for involuntary treatment has to be filed, or it can be voluntarily committed. It's 72 hours.
Okay.
And then the other question rolled in there is if there's a distinction about whether a person is at an emergency department or in a psychiatric unit of a hospital. And I didn't know the answer to that question. I posed it yesterday to Dina Monahan from GMH, Jill Olson from the Hospital Association, Jack McCullough from Legal Aid. I got a response from Jack, and he didn't think that the statute distinguished for the purposes of admission between an emergency department and a psychiatric hospital unit. So it was his understanding that regardless of where a person was when they were admitted, that's when their clock started ticking.
Can you repeat for me? I thought what you first said was the 72-hour time frame starts after they've been EE.
Emergency exam. So they have come in.
So can we start with who and where does an emergency exam happen?
So an emergency exam has two parts. The first part happens outside the hospital. That's an application and a physician certificate. If if those two pieces are completed, the person can be transported to a hospital. And at the hospital, there's a second sort, which is the psychiatrist exam, so a second review. So that can happen wherever the person is. If the person is at the emergency department, it can happen
So
there.
both of those things happen being a non-lawyer. The emergency exam has happened. So the 72 hours should start.
After the second
After
cert.
the second one, and the second one could happen anywhere.
Could happen at the emergency department or at the psychiatric
Okay,
unit of the
so
hospital.
if other things are happening on the ground, that's not, which, and maybe we can't follow, maybe state law doesn't make sense anymore, but as a non-lawyer, it seems like law says one thing and practice is having another. You know? Oh, God.
So this has to do with the second significant change in S-287 as proposed by the Senate, and that is to allow a motion for an expedited application for a voluntary treatment hearing. And this doesn't replace the existing application for voluntary treatment hearing, rather it's an alternative option when certain showings are made. So those showings are, first, that the person received involuntary medication during the past 2 years and experienced significant clinical improvement as a result, or, two-part test, the person demonstrates a significant risk of causing the person or others serious bodily injury even when hospitalized, and clinical interventions have failed to address the risk of harm to the person or others. So that, under those circumstances, the court has discretion to determine if he or she would like to expedite the hearing. If the court does decide to expedite, the hearing would occur between 7 and 10 days after the court grants the motion to expedite. And that is compared to the 10 or 20 days timeline after, for the regular existing application for involuntary treatment, depending on whether there's a psychiatric exam requested.
I decided to work with people who were psychotic, and I'm going to explain a little bit more about what I mean, but people who are maybe hearing voices or believe things that other people don't believe. And at that time, I pretty much embraced the sort of general concept of the field, which is this is a medical illness, and that the best treatment, or the core of treatment at least, is to treat it in a medical way with medications. But what I saw from my vantage point of being a small-time doctor is that there was misinformation out there, that there was misinformation that was being propagated by the leaders of our field during the 90s, and that's the point when I was in Vermont at this point, and I had been sort of in academic centers, and now I was working in a clinic at the Howard Center, and mostly working with people with psychotic disorders. I really became disgusted with the influence of pharmaceutical companies on the practice of medicine. And this affects all of medicine. In some ways, I think psychiatry might be particularly vulnerable, but it's a general problem in medicine. So by the 2000s, that was sort of my framework. I was very angry and discouraged in a lot of ways. I would read studies and see what the studies showed, and then I would see what sort of the general belief was, and they were discordant. And along the way, I then began to read about long-term effects of these medications. So a lot of the drug company studies focus on short-term trials. So you give someone a trial, 6 weeks, you look for evidence if it works. And again, I thought there was distortions in that. But what happens in practice, particularly with the drugs used to treat people that are psychotic, is they're then on them for decades. And in my sort of reading, I came across a book that asked this question, what happens in decades? And I thought that there was, this person, a guy named Robert Whitaker, wrote a book called Anatomy of an Epidemic. His hypothesis in the book is that we don't really know, but what's out there suggests in the long run, these drugs do more harm than good, or they do some harm that we're not recognizing, I would say. So why should we care about this? Why should you care about this? You know?
Oh, my name is Ed Paquin, and I'm the president of the Vermont Coalition for Disability Rights. And we've been speaking out in opposition to S-287, which is an attempt to speed certain parts of the process of involuntary medication. In general, we are not. We believe in the statement in Title 18 that the state should be working towards a system that is less reliant on involuntary treatment and specifically involuntary medication. And we feel that by speeding the process in the way that this bill proposes, we're very likely going to see an increase in the amount of involuntary treatment. People generally who take some time for their legal issues to be resolved through the system, most people before they reach any kind of court adjudication of their status, whether it be the commitment step or the step of involuntary treatment, most people engage at some point with the providers and will consent to some level of treatment. And by folding the two processes together, we believe that there will be an increase and not a decrease in the amount of involuntary treatment. And the key, the way I look at it, the key to that is that there's a trade-off. It may very well be true that some people will do better if they are medicated in a shorter period of time. However, when you introduce involuntary nature of forced treatment, forced drugging, however you want to call it, you're trading off that small amount of extra time that it takes to go through their due process rights for an attitude towards their providers that may last a lifetime. There may be a lifetime of disengagement that an individual embarks upon. So I'll leave that with you as a thought.
I'm speaking with Jack McCullough from
the Mental Health Law Project of Vermont Legal Aid.
Thank you, sir. Would you like to comment on today's proceedings?
Sure. It's the very beginning of the process in the House of Representatives. We have serious problems with the legislation. We think that the bill is going to deprive people of their due process rights, and we think it's going to increase the amount of involuntary medication that takes place in Vermont's hospitals. And so we're opposing the bill. We'll continue to try to work on the bill to improve questions that are problems now, and we'll be working very hard on the bill over the next weeks to months.
So it's about changing language in the bill, or are you presenting alternatives to the present plans?
We have presented alternative language in the Senate. We will be proposing alternative language in the House, and we hope that our language will be adopted through the way the bill is what's going to happen in the bill.
So you expect this to take, not to be able to be decided upon immediately. It's going to take some more time processing, possibly into next year, would you say?
I don't expect it'll go to next year. If it goes to next year, they'll have to start over from the beginning. But in the House, it'll have to go through at least 2 committees to look at the details, some of the details that we were talking about this morning. And we hope to have a serious opportunity to make our points and have an impact on the bill.
Thank you very much, sir.
You're welcome.